Hello everybody and welcome today. Thank you for joining me from wherever you are, whatever time you're seeing this video. So today's Daf is Daf 30 Amud A from Shevuot. Let's dive in. The Mishnah. Shevuot ha'edus noheges ba'anoshim v'lo b'noshim b'chukin v'lo b'krovin b'shavin v'lo b'sulin v'eno noheges Ella ba'uyin laha'ir. The oath of testimony. So what does that mean? A Shevuot ha'edus, an oath of testimony. An oath of testimony refers to a case in which a litigant claimed that witnesses have information supporting his case and requests that they testify in his behalf, and they deny that they have such information and refuse to testify. They are required to take an oath to that effect. If in actual fact they could have testified and they take a false oath that they could not, and by doing so they caused the litigant a loss, then they are liable to bring a sliding scale offering as an atonement. It's practiced with regard to men, but not with regard to women. So what does that mean? But anoshim v'lo b'noshim. The Gemara discusses the source for the exclusion of women from this halacha. Rabbi Akiva Eiger asks, aren't there cases in which a woman is deemed credible by Torah law, e.g. a case of sota? He answers that the language of the verse and he is a witness, Leviticus 5:1, in the case that the oath of testimony is administered to one who may be characterized a witness. The fact that a woman is deemed credible in certain cases is not a function of the halachot of testimony, rather it is due to other reasons involving credibility. The Netziv explains similarly that one is characterized as a witness only if he is eligible to testify in all cases. With regard to non-relatives of the litigants, but not with regard to relatives. With regard to those fit to testify, but not with regard to those unfit to testify due to the transgression that they performed. And the oath of testimony is practiced only with regard to those fit to testify. So what does that mean? Shevuot ha'edus ein noheges ela ba'uyin laha'ir. The halacha of an oath of testimony applies only to those fit to testify. If one of the witnesses was a relative or disqualified from serving as a witness, even if his disqualification was by rabbinic law, or one of the witnesses was the king, one does not testify in court, or if the witnesses did not witness the incident firsthand and the testimony is based on hearsay, even if one of these individuals took a false oath that he has no knowledge of the relevant matter, he is exempt from liability in accordance with the Mishnah and the statement of Rav Aha Bar Yaakov on 31a, Rambam Sefer Aflah Shevuot 10:1. The oath of testimony is practiced both in the presence of a court and not in the presence of a court, when the potential witness takes the oath on his own. But if the oath is administered by others, and those denying that they witnessed the incident in question neither take an oath nor answer amen to the administered oath, they are not liable until they deny any knowledge of the incident in question in court. This is a statement of Rabbi Meir, and the rabbis say whether one of the witnesses takes an oath on his own, ben b'fi atzma v'chudu, witnesses are liable for taking a false oath of testimony only if they deny any knowledge of the incident in question in court. There is no difference whether they take the oath on their own or whether the oath is administered to them by the plaintiff. Even if they took the oath or had the oath administered to them outside the court and falsely deny knowledge of the incident in court, they are liable for taking a false oath of testimony. That's in Rambam Sefer Aflah Shevuot 9:2. Or whether the oath is administered by others, the witnesses are not liable until they deny any knowledge of the incident in question before the litigants in court. And one is liable for taking the act of taking a false oath with the intent for an unwitting act of taking a false oath. One who is liable for taking a false oath of testimony brings a sliding scale offering, whether he took the false oath intentionally or did so unwittingly. What is an unwitting false oath of testimony? It is an oath taken when the witnesses are aware that they are lying, and they are similarly aware that it is prohibited for them to take that oath, but they do not know that they are liable to bring an offering for taking that oath. If they were unaware that it is prohibited to take the oath, or if they forgot the testimony and took an oath that they have no knowledge of the incident, and later recall the incident, the halacha stated is that of one who took a false oath due to circumstances beyond his control, and they are exempt from bringing an offering. Rambam Sefer Aflah Shevuot 1:12-13. I.e., he is unaware of the liability for taking a false oath, provided that he takes the oath with the intent in terms of the testimony, i.e. he takes an oath that he has no knowledge of the matter, even though he knows that he witnessed the incident. But witnesses are not liable for taking the oath if they were unwitting in terms of testimony. So what does that mean? Rashi explains that the reference is to a situation where they took the oath unwittingly, as they were under the impression that they did not know any relevant information concerning the matter, and they later recalled the matter. The Rambam questions that explanation, as if that were the case. He goes out saying that they would not be liable, as when they took the oath they believed it to be truthful. Therefore, the Ramban explains that the reference is to a case where they took an oath that they never had knowledge about the matter, or a case where they were uncertain whether they had knowledge or any relevant information that they took the oath despite that uncertainty. The Rashba notes that the straightforward reading of the Tosefta supports Rashi's understanding. The Rana concludes that even according to Rashi, it must be explained that the oath that they took was not a truth oath, as after consideration they recalled the matter. The Rambam and Tosfot in 31b explain that the oath was unwitting, as they did not know that it is prohibited to take an oath under these circumstances. So in testimony, i.e. they believe that they had no knowledge of the matter, and what are they liable for by taking a false oath with intent? They're liable to bring a sliding scale offering. Gemara. The Mishnah teaches that the oath of testimony is not practiced with regard to women because they are unfit to testify. The Gemara asks, from where is this matter that women do not testify derived? The Gemara answers, it is as the sages taught in a Braita, when the verse states, if an unrighteous witness rises up against any man, then the two men shall stand. Deuteronomy 19:16-17. It is with regard to witnesses that the verse is speaking. Apparently men, not women, may testify. The Braita continues, do you say that with regard to witnesses, or perhaps is it only with regard to litigants that the verse is speaking? When it says between whom the controversy is, Deuteronomy 19:17, the litigants are already stated in the verse. How do I realize the meaning of the phrase, then the two men shall stand? Apparently it is with regard to witnesses that the verse is speaking. And if it is your wish to say that this is not a proof, another proof may be cited. It is stated here, two men, and it is stated there on the basis of two witnesses, Deuteronomy 19:15. Just as there, it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. The Gemara asks, what is the meaning of the statement of the Braita? And if it is your wish to say, why is the initial proof inadequate? The Gemara answers, if you would say that from the fact that the verse is not right, then the two men and those between them whom the controversy shall stand, which would indicate that the verse changes its focus from the witnesses to the litigants. Perhaps throughout the entire verse it's with regard to the litigants that it's speaking. Therefore, the Tana cited an additional proof. It is stated here, the two men, and it is stated that on the basis of two witnesses, just as there it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. And it is taught in another Braita, when the verse states, then the two men shall stand, it is with regard to witnesses that the verse is speaking. The Braita continues, do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? The Tana asks, did you say that? If the reference is to litigants, why does the verse mention two? Do two people come to court for judgment, but three people do not come to court for judgment? And if you wish to say that this is not a proof, another proof may be cited. It is stated here the two men, and stated that on the basis of two witnesses, just as there it is with regard to witnesses that the verse speaks, so to here it is with regard to witnesses that the verse speaks. The Gemara asks, what is the meaning of, and if it is your wish to say, why is the initial proof inadequate? The Gemara answers, if you would say that even though there are cases where there are more than two litigants, it's with regard to a plaintiff and a defendant that the verse is speaking. Therefore, the Tana cites an additional proof. It is stated here, the two men, and stated there on the basis of two witnesses. Just as there, it's with regard to witnesses that the verse speaks, so to here, it's with regard to witnesses that the verse speaks. It is taught in another Braita, when the verse states, then the two men shall stand, it's with regard to witnesses that the verse is speaking. Women are disqualified by Torah from providing testimony. Rama Sefer Shoftim Hilchot Eidat 9:2 Shulchan Aruch Mishpat 7:4-33:1. The Braita continues. Do you say that it is with regard to witnesses, or perhaps it is only with regard to litigants that the verse is speaking? The Tana asks, did you say that? If the reference is to litigants, why does the verse mention 10? Why does the verse mention men? Do men come to court for judgment, but women do not come to court for judgment? If you wish to say that it is not a proof, another proof may be cited. It is stated here the two men, and it is stated there on the basis of two witnesses. Just as there to regard to witnesses that the verse speaks, so to here to regard to witnesses that the verse speaks. The Gemara asks, what is the meaning? And if it is your wish to say, why is the proof inadequate? The Gemara answers, it means, if you would say that with regard to a woman, it is not typical conduct for her. The Tosfos asks, if so, perhaps the verse with regard to testimony is written in terms of men, because it's typical conduct for men to appear in court, while women, due to the verse, all the glory of the king's daughter is within, in Psalms 45:14, do not typically appear in court, and the verse does not exclude women from providing testimony. Tosfos explained that if she were a litigant, she could designate an agent to represent her in court, but there is no agency with regard to testimony. Therefore, the fact that it is not typical for a woman to appear in court would not justify her failure to testify concerning an incident that she witnessed. To appear in court due to the verse that is stated with regard to women. All the glory of the king's daughter is within in Psalms 45:14, and that is why the verse addresses a situation that is prevalent, i.e., a case where the litigants are men, and there is no proof that women are unfit for testimony. Therefore, the Tana cites an additional proof. It is stated here the two men, as is stated there on the basis of two witnesses, just as there is regard to witnesses that the verse speaks, so to here is regard to witnesses that the verse speaks. The Gemara cites another interpretation of the verse. The sages taught, then two men shall stand. This indicates that there is a mitzvah for the litigants to stand during the court proceedings. Rabbi Huda said, I heard that if the judges wish to seat, the early commentators know that it was stated only during the stage of deliberations, but when a verdict is issued, even Rabbi Huda concedes that the litigants are required to stand. Rabbi Huda also concedes that there is a mitzvah for the witnesses to stand throughout the trial, Abba Benisha, and that's from Tosfot. Both of the litigants, they may seat them. What then is prohibited for the judges? They must ensure that there will not be a situation where one litigant is standing. Shelo Yehei Echad Omeid. There may be a situation called where both of the litigants are standing while the other is sitting. Both should stand. If it pleases the court, the judges may seat them both. Sanhedrin 21:3, Shulchan Aruch Mishpat 17:1. And one of the litigants is sitting, or a situation one of the litigants says everything that he needs to say to present his case, and one litigant, and the judge says to him, curtail your statement. The sages taught, the verse states, but in righteousness shall you judge your calling, Leviticus 19:15. There is a mitzvah for a judge to adjudicate cases with righteousness, as it is written, but in righteousness you shall judge your colleague, in Leviticus 19:15. What is a righteous sentence? It is a sentence that concludes a trial where the judge treats both litigants equally. Accordingly, the judge must not allow one litigant to articulate his claim expansively while forcing the other to articulate his claim briefly. Similarly, a judge must not address one litigant courteously and the other harshly. One must say for Shevuot Daf, Sanhedrin 21:1, Shulchan Aruch Mishpat 17:1. From which it is derived, the court must ensure that there will not be a situation where one litigant is sitting and one litigant is standing, or a situation where one litigant says everything that he needs to say to present his case, and one litigant, the judge says to him, curtail your statement. Alternatively, it is derived from the verse, but in righteousness shall you judge your colleague, and that you shall judge another favourably. The reference here is not to a litigant standing before a judge, as in that case the sages advise that the judges to view the litigants as though they were wicked, in Avot 1:8. Rather, this refers to one who observes another performing an action. Although at first glance it appears that he is performing an inappropriate action, one is required to attempt to ascribe positive intentions to that individual and interpret his action in a favourable manner, Rashi Shabbat 127b, and seek to find justification for his actions, even if when interpreted differently his actions could be judged unfavourably. Rav Yosef teaches from the verse, but in righteousness you shall judge your colleague. It is derived with regard to one who is with you, in observance of Torah and in fulfillment of mitzvah. Try to judge him favourably in the manner that the Gemara will now explain. The Gemara relates, Rav Ula son of Avilai had a trial pending before Rav Nachman. Rav Yosef sent a message to Rav Nachman, Ula, our friend, is a colleague in Torah mitzvah, with regard to whom the verse states that you should judge him favourably. Rav Nachman said, For what purpose did he send this message to me? Did he expect me to grant him preferential treatment? Every judgment must be taken with righteousness. Rav Nachman then said, Rav Ulla sent me the message to ensure that I would open Rav Ulla's dispute. In the event that other cases come before me for judgment in deference to the Torah because he is a Torah scholar. The Mishra Besigri. If there are several cases that come before the court for adjudication, they should be tried in this order. Cases involving orphans taking precedence over cases involving widows, and both take precedence over cases involving a Torah scholar. Cases involving a Torah scholar or his agent take precedence over the case involving an Amahoris, even if the Torah scholar arrives in court later. There is a dispute among the later commentators whether present-day Torah scholars qualify as Torah scholars with regard to this halacha. Rama Sefer Shoftim Hilchot Sanhedrin 21:6, Shulchan Aruch Yoredeya 243:5, Choshen Mishpat 15:1, 2, and see the smile there. Thank you for listening and all the best. Bye.